I would like to introduce our managing partner, Mr. Ravi Singhania. Mr. Ravi Singhania is an alumni of SRCC and Campus Law Center, University of Delhi. He started in his legal career in early 90s as a litigator, did some transactional work in India and New York, and then established the firm Singhania Partner in year 2000. Since its inception, firm has been assisting the biggest player who are driving the infrastructure growth in the country, including National Highways Authority of India, Indian Railways, Gujarat Maritime Board, and many more. Ravi sir has been on board position with Fortune 500 companies, and he has rich experience of representing contractors, concessionaires, and consultants. So we are on the panel of NHAI, GMB, etc. That doesn't mean that we are not supporting the private players. So, and after working for him for now 7 years, I can say that he's a nationalist by heart and passionate and very positive about India's growth story. And he firmly believes that infrastructure development can take India to new heights. Over to you, sir. Thank you.
Thank you, Khushbu. It's a pleasure to welcome all of you this morning. Good morning. After a long time, we are having such an event in person, and I guess I'm glad the webinars of all of this knowledge has changed to in-person back again. We have a very interesting 3 sessions this morning. The first one is on expert evidence. The second one is non-signatories being bound by Arbitration Act, by arbitrations agreements. This is based upon some of the latest development in this area. And the last, my colleagues would be discussing on the latest trends in infrastructure projects. But more than that, what we have today is some very interesting panelists. The first panel where I'm moderating the same, we have Justice Sistani, a very learned judge from Delhi High Court with many decades of experience as a lawyer, as a judge, and now back in the bar as a senior counsel of Supreme Court, as well as arbitrator in many matters. We have Jagvinder Singh from KPMG, who is a chartered accountant and partner there, as well as he is an expert on damages, delay damages, and now leads their forensic practice, where expert evidence by his team is very important. We have Shishir Kant from Masin, who are engineering consulting advisors on these infrastructure projects and who have acted as expert evidence, Shishir personally, in many domestic and international arbitrations. And last but not the least, my colleague and a partner with us at NHAI, along with KPMG for construction contract management there. So we look forward to some exciting discussions later today. And I'm glad we have been able to partner with CII to have this wonderful audience today. Thank you. So with that, we begin our first session.
Before we proceed, may I request our managing partner to please please felicitate Justice Sistani with the bonsai plant. Thank you, sir. Thank you for taking out time to join us today. May I request now to sir, please present the books to the rest of the panelists. So we did a book on white collar crimes in India 2 months ago. It got published with Thomson Reuters. So Justice Sistani has already read the book. So and so a copy of the book for the rest of the panelists, Mr. Shishir Kant, Mr. Jagvinder S Brar, and Hitesh. We don't get to see him very often, so one for him as well. Thank you. We'll be starting now. Thank you.
good morning again. We have a session on expert evidence, and here we have experts. We have Justice Sistani, as well as a contract management expert at NHAI here with us this morning. Expert evidence was not a known quantity in the Indian arbitrations a few years ago, but I think now with the complex infrastructure projects, it has become a very important aspect of the arbitral dispute resolution. To begin with, I would start from the legal side and perhaps pose a question on the panel itself and ask Justice Sistani also for his expert comments. The first thing the Evidence Act says is the Evidence Act is not applicable in arbitrations. And the Arbitration Act says the arbitrator is the best judge of the evidence being presented. So what do you think, is this a dichotomy or is it?
Good morning, everyone. See, Ravi, the answer really lies that as per the Arbitration Act, even strict rules of procedure, that is the CPC, would not apply. But be it summoning of witnesses or interrogatories or various other provisions of the Code of Civil Procedure are applied in arbitration proceedings. So I think although strict rules of evidence would not apply, and they do not apply, but we always borrow whatever applies and whatever are the guiding factors. You see, even in Section 9, you say that CPC would not apply. But does it mean the principles laid down under Order 39, Rules 1 and 2 would not apply? Or does it mean the law laid down for Order 38, Rule 5, which is attachment before judgment? Those of you who are familiar, that Order 38, Rule 5 is used in a very stringent manner, in a very straight jacket formula. You know, you have to show in your application that there is every likelihood that the person whose property you seek to attach before the pronouncement of judgment is either going to run away from the jurisdiction of the court, or his background is such that there is every likelihood that you would not reap the fruits of your litigation. So we do borrow whatever is required, be it from CPC or be it from the Evidence Act, and I don't think we can really escape. But then I again underline that the strict rules would not apply. It's not that at every stage, if somebody was to introduce documents, you would say, no, no, your stage is gone, you should have filed them with the pleadings. But then rules of prudence say that if you don't, then you will have problems in limitation. Limitation as in writing the award and completion of pleadings. So arbitrators also have to draw a line, have to fix rules, and procedure allows it.
Taking it further on the legal, judicial side, the International Bar Association as well as the Chartered Institute of Arbitrators, they have quite comprehensive guidelines on the expert evidence, how it should be taken and what should the process be. But I guess what I just heard in the Arbitration Act as well as the Evidence Act, you are borrowing the jurisprudential rules or principles of law as far as the evidence is concerned, but not applying them in a strict sense. So would that hamper, a lot of the experts, they are paid experts. Right. So when you're looking at these awards from a judicial perspective and challenge that the expert whose evidence has been relied on, would it mean that they, the Arbitration Act in Schedule 5 and 7, it says there are processes to be, rules to be considered when you're considering an arbitrator. Mm-hmm. Similarly, the expert would also be viewed in the same light, sir?
Well, some moral science lecture. You see, everything boils down to the aspect of integrity. be it an arbitrator, be it a judge, be it a lawyer, be it a mediator, be it a chartered accountant, and the expert witness is included. Let me just give you some non-arbitration related examples. You know, sitting on the criminal board, at the appellate stage, sometimes you would get an application saying at the time of the crime, I was a juvenile. Now, the law as it stands says that even at the appellate stage, even if the person has been convicted and has been undergoing imprisonment, incarceration for 10 years or 8 years, you are supposed to entertain that application. Now, if the certificate comes from one or two of our famous states, without naming them and offending anybody, would you accept them? You'd probably look at it with a couple of magnifying glasses. And let me also share with you, 8 out of 10 were forged. But if you get a certificate from Delhi or a couple of other states, you would be reasonably assured. Of course, you do have to make a check. You do ask the IO to go and do the verification. What they will do in some of the states is they'll first look at the father's name. So if there is Mr. Ramlal, they will start searching registers. And the moment they find Ramlal, son of Shamlal, certificate will be made. Right? So this is a crude example, but I'm trying to apply it. How does the court or an arbitrator look at an expert witness? Would you not like to see the background of the witness? Would you not like to see the kind of qualification, for example, in their line and in construction line? Suppose you come across an expert witness who has absolutely sterling quality past and qualifications. Of course, his testimony must relate to the subject in issue. But sure enough, as an arbitrator or as a judge, you would stand reassured. As in court, when you see Mr. X appearing, you normally judges look at a lawyer, and if he makes a statement, it's taken to be correct. But then some people get that tag that, look, you better be wary of Mr. X. He will always mislead. He will refer to documents not filed, or his documents would be a suspect. So what I'm trying to get at is the judge or the arbitrator should be persuaded by an expert witness. If he is a qualified witness, Evidence Act defines, you know what are the qualities or the qualifications of an expert witness. And if he's not been branded as a stock witness, his testimony relates to the subject, to the meat of the matter, and he's able to sort of back it up. I see no reason why any court or any arbitrator should disregard that evidence merely because the witness has been paid. He's an expert witness. Now, one aspect which has been noticed is that you may try and browbeat him, you may try and lead him to issues which is not related, and he will also try if he is one of the stock witnesses. Now, that's the point where he must stop. He must say, look, this is the evidence I have given. This is what I have looked at. Look at it, may be a machinery, it can be construction, it can go to the site and say what is the quality of steel used or whatever it is. And if he stops at that, then he's a respected witness. And I see no reason why his evidence should not be looked at.
Thank you, sir. Let me move to the experts for a moment, and I'll come back to stock witnesses a bit later. But Shishir, if I ask you, do you really need a witness in arbitrations? Expert witness.
Good morning to everyone. As per my understanding, it depends upon the complexity of the dispute which is under the arbitration, which requires the engagement of expert Briefly, I can say that the arbitration process is quite flexible in comparison to the court process. So therefore, all the stakeholders, the parties as well as the tribunal, they have a flexibility to adopt the strategy regarding the expert testimony during the process of arbitration. I have seen in certain cases whereas at the commencement of the arbitration there was no requirement of expert testimony. In the due course, it was realized by the parties as well as by the tribunal that expert testimony is required. So therefore, what I can say that there are certain decision points, strategic points that has to be decided during the course of arbitration. First is that definitely that whether the expert is required in the arbitration or not. The second decision point is that once it is decided that expert should be there, then whether it should be the party appointed expert or the tribunal appointed expert, then what will be the stage at which the expert testimony or witness should be introduced in the process, then what will be the selection of the experts by the parties, and then there are certain strategic points also related to the you can say expert statement, main report, reply report and joint statement like this, and at the time of cross-examination what will be the strategy to be adopted by the parties as well as the counsels related to the expert testimony. So I can say that there are several decision points that has to be considered, not only from the start of the arbitration process, but during the arbitration process that has to be decided on expert testimony. Thank you.
Jagvinder, would you like to add something to that?
Thank you. No, I concur with Shishir ji. I think even if we go outside of India, right, if we look at the jurisprudence, going to UK or, I also had the opportunity to depose in Canada and US. There are very well established, decided cases. And I think the expert evidence in some of these countries is slightly more mature. Where, for example, in Canada, there were certain rules of even deposing, when to involve, when not to involve, and also the competence, for example, what should the report of an expert must have. So there are very sort of, through experience and through some of the issues that Justice Sistani spoke about, the integrity questions, that were raised on certain experts. So I think if we get over with the objectivity, independence, and all those things, expert evidence is extremely crucial for delivery of justice. And therefore, I would say that it is important that experts are involved.
I may request Justice Sistani now, as an arbitrator, what would you prefer? Would the experts be appointed by the parties and they bring their own experts, or the tribunal should consider appointing an expert to assist the tribunal?
Actually it really depends on the facts of the case. For example, in one of the matters, this is a matter which is sub judice against an insurance company. Now there was a fire. What led to the fire? See, the tribunal now asking an expert to get into it, an issue which took place 5 years back, etc. I really don't think we will be able to reach to any firm conclusion. But certainly the parties would be free because they were present, the surveyor was there, the parties would be there. So they would be best equipped to bring their own witnesses. But if you expect that the claimant's expert witness and his opinion would be accepted by the respondent, or the respondent's opinion would be accepted by the claimant, that's never going to happen. It doesn't even happen when we used to get opinion from the forensic science laboratory. So you get a report from the forensic authority on any matter, one side or the other would say, no, this report is flawed. So obviously you have to make your own conclusions, you have to weigh the evidence before you. That's really your job, whether as an arbitrator or as a judge. And by far, I say, even as a lawyer, in your heart of heart, as you're doing a matter, or as an expert to expert, as you are examining somebody's opinion, you're playing this game against yourself. So the good part about arbitration, as Mr. Singhania just said, these strict rules don't apply. So you can cut across the formalities of those rules and really go hard into the matter and find out what really happened. In court, you normally don't interact directly, with somebody. But in arbitration, at least speaking for myself, I would have no real reason to keep him away and ask him, "Ke bhai, acha batao hua kya? Zara samjhao to sahi." And there are so many issues. And there are various and very, very complex things, as Mr. Kant pointed out, and Jagvinder did. They can be very complex matters. Lawyers may be not ready to look at them, even as judges, arbitrators. So you do require somebody to explain, and then it's up to you to understand and then take a call and see where the weight really is.
Thank you, sir. Let me put the question to the floor now, and maybe start with Hitesh. Hitesh, like being in the client shoes in some form right now, I would say, like, how do you select experts? What is the basis for selection of an expert?
Okay, good morning to everyone. See, technically, there is no qualification prescribed under the law, and that cannot be the desired state also. But as in one of the cases, the Supreme Court in state of HP versus Jalal, if I remember correctly, the court has said that the expert witness must be the one who has acquired a specified knowledge on a given subject, or he has acquired qualifications or practiced that as a profession. So that is the most fundamental. So while selecting an expert, we need to not only look at the qualification, but also the experience, the relevant experience, whether he has worked on those areas or whether he has handled such similar assignments in the past, and what was the outcome, what was the finding, and whether those were accepted or not accepted. So that background check is necessary. Just going by the mere qualification will not help, because it's not an academic exercise. Obviously, he has to analyze something. He has to give his opinion on a subject, which will be subjected to further examination by the other side or by the judges or by the AT. So the selection of expert witness is very, very important.
Thanks, Hitesh. I think that really nails it down. But Shishir, what's your take on it?
My understanding is that in arbitration process, the tribunal is the final audience, and the expert is like one of the performers. So the objective of the parties as well as for the tribunal is the performance should be good and it should be well received by the final audience. So for the selection of any expert, not only the, you can say, past experience and other qualifications matter, but at the same time, what I also see that there are, I can say that there are certain socio-political reasons also included while the selection of the expert in relation to the constitution of a tribunal. I can give one example. In Indian arbitration case, what happened that the claimant has very complex delay related issues, and then he decided that expert witness will be required for his case, and he preferred to have a Western expert for the, you can say, expert testimony. So at the time of commencement of arbitration and formation of tribunal, the claimant has decided that he will be opting for a Western arbitrator who can understand the construction law at, you can say, as per the international arbitration exposure, and therefore his Western expert will be much more suitable to explain the delay related issues to the tribunal and especially to that particular arbitrator. So therefore, I can say that what is the final audience as well as the performer and how it, the both should, you can say, act in efficient way, and the objective is the party's objective will be always that his expert will be guiding the tribunal on the matter of dispute under his expertise. So that is my take on this. Thank you.
Let me ask a financial view to it, and ask Jagvinder, like, how the expert you feel should be selected, like, just to.
Yeah. No, I think briefly, the criteria for qualification, experience, credentials, as Hitesh spoke of, I think that is the fundamental thing, because the expert must bring in something which is not there already, with the tribunal. There must be some specialized knowledge. Now that knowledge, of course, can be engineering knowledge, can be structural knowledge, can be, financial knowledge as well, because as much as we think that, a lot of delays, claims for, delays or, some breach of contract or termination can be understood, when you actually get into the nitty-gritties of the claim, the heads of damages that may be there, or heads of damages that may be already excluded from the contract sometimes. It is not responsibility of one party. I think it is the devil lies in the details. And what the expert can help you understand is bring out those things, openly and say, this is how things can be handled. And that can be the real assistance to the judge or the arbitrator or the tribunal, and also both the parties in the interest of justice. Because absent that, if the, let's say, award is subject to further challenges, and it gets established somewhere later that, look, expert should have been involved because someone took the role of some specialist which that person was not, then again, the entire exercise can go for a waste. So therefore, I think those are the key reasons I would suggest having an expert.
I would say that, like, instead of blowing your own trumpet, if you have an appropriate expert, whether it's a technical expert or a financial expert who has the subject knowledge, and coupled with the socio-economic, like, conditions or the socio reasons in the tribunal there, whether to have a domestic expert or an international expert, I think an overall perspective would give you a better view as to who the expert should be. That leads me to, like, I may ask Justice Sistani, that when should be the expert report be adduced? Should be along with your pleadings, or post completion of pleadings, and where you would add them?
See, I think law gives you a chance at both the stages. But unless you lay the foundation in your pleadings, you can't spring up something in evidence. So you will introduce some flavor in your pleadings, and then maybe back it up with the evidence of the expert. But again, I would underline that when you talk about an expert, then he must be an expert in his field. I may be a very good physician, but that doesn't mean that I'm a good surgeon. So when you need the evidence of a surgeon, you can't introduce the best physician. So his evidence will be taken lightly. So in the same way, if you have a building contract, you need somebody who, because the first question will be, what is your qualification? What has been your experience? Have you, in your years as an engineer or as an accountant or a forensic person, have you come across any such matter in the past? Have you got an opportunity to look at it? And if your answers are no, 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 then the judge or the arbitrator will get a feeling that here is a man who is himself has had no experience on all this and is given a 40-page report. So obviously it's procured. So it's extremely important that if you are getting a subject expert, then that expert should be an expert in his line, his field, and not somebody on the broader aspect. Why would you engage the services of the top-ranking companies like KPMG? You can get somebody from Parganj. He'll put the same on the letterhead. Jo bologe chhap dega. What is the problem? Would you get the same confidence as Mr. Brar would give you? Why? That's the time you're going to look at many other things. Today, most of us, even if we go to a doctor, even if your friend recommends it, what do you do? What is the first thing you do? You run to Mr. Google and say, let me check what all has he been doing, what has he been up to. And some of the most negative people will also start looking at how many complaints against him before going to see him. So here we don't do that as judges or arbitrators, but our good friend sitting on the other side will dig every possible thing available against that expert witness. Every possible stricture which may have been passed or may not have been passed. And in the most polite way, it will be slipped in. Do you remember that matter? You were there. I'll just refresh your memory and read the most ugly lines written against him. Not only his memory is refreshed, everybody gets refreshed. So these things do matter. You can't put them under the carpet. He may be your good friend, stock witness. He'll say everything good about it. Unless he's making good sense, why would you listen to him?
Let me ask you, sir, regarding stock witnesses, either we would go to KPMG or we would go to Masin in terms of getting a witness, expert evidence. Would they be considered our stock witnesses or they're experts?
See, it's their reputation. If the reputation carries that they will not make a statement which is not true, if they carry a reputation that you can just send a check or something else and you can get anything from, whether it's KPMG or it's Mr. X, Mr. Y, Mr. Z. When I say Mr., it's gender common because it can be either. So that's where, coming back to your model science, we all look at things in that perspective. Again, let me tell you, you must have heard about in criminal law these ballistic experts. When those famous Jessica Lal case, etc. came up, it was all in the newspaper. That one Mr. Rooplal or somebody, he would be able to give evidence in every matter. So right, he's there, he can give evidence. Whatever, these are all, they have to be tested. But then, we are not experts. Let me share, I don't know how much time we have, a very interesting thing. I never did criminal law as a lawyer, didn't do much of it. And as a judge, I sat a lot on the criminal bench. So I told my senior judge one day, in every matter, they use a country-made pistol. It's called a katta. So I told my brother, I said, "Sir, katta mangaye the, so let's call for it." So he said, "This is all. Don't get into all this." So he kept saying, it could not have reached the bullet because the moment you fire from a katta, the barrel breaks, etc. This, that. So I was sitting with Justice Chaturvedi. So again I nudged him. I said, "Ji, maine to kabhi dekha nahi hai." This was, I think, 2007 or 8 or something. So ultimately he said, "Acha, to manga lo." So he said, "Get it." And it was one of the best kattas. And the barrel was completely intact. Nobody had bothered to see it. And then we started doing some research. We got a lot of books, which there are international books, which gives you description of every kind of bullet which is fired. And when the bullet is fired from a particular barrel, it leaves a particular mark, right? So we were not expert witnesses, or we were not experts, but we went deep into it. We didn't get that kind of assistance because the trial was all done and gone. And So you can still, at least you familiarize, you come to know. You know you're not being taken for a ride. So experts do have a role to play. You can't neglect them.
Thank you, sir. Let me ask Hitesh, from a perspective of stock witnesses to the perspective of interaction with the experts at at your client, how would you take it? You would brief the experts, interact with them, or what is your level of interaction with them to prepare the expert evidence report so that it can be presented to the tribunal?
See, from a strategy point of view, I think when a dispute has cropped up, the parties would know that most likely that they would require some sort of technical expert or assistance. So from a strategy perspective, I think the advisable would be that they should engage the expert from the beginning, because that will help them in building up the claim or counterclaim, as the case may, from a different tangent. Because ultimately your claim and counterclaim is going to be contested by the other side. And by engaging witness from the beginning, I think that will help you to prepare a robust case. So that is one. Second is, suppose because normally when we call expert or expert witness, so normally perceptions comes to mind that this is something which will be engaged in the middle of the proceedings, or once some certain stage has crossed in the proceedings. But I think if it is feasible, or strategically it has been decided by the parties that they need to engage a witness, expert witness, they should engage from the beginning. So once we have an expert witness on the table, so I think we will have interactions. He will help us in preparation of claim, quantification, damage analysis, and all that. So that will also bring confidence, and that will also help the parties to prepare from a legal and also from a technical perspective where our case stands. And second is also, it is also a strategically it is also important for the other side. Suppose if the one side has presented a witness and he has presented a report, to examine it. So it is not that the report has come from an expert, even if his name is very big at global level, that should be accepted on the face of it. Other party will have a chance to contest it, and ideally they should contest it. So examine the witness, because that will bring out the strength and weakness of your case also, and the strength and weaknesses in the expert's report also.
Thank you, Hitesh. Before I move on, let me ask Jagvinder, what's your take on the interaction of the experts with the client?
So the interaction with clients, for experts, I think right from the beginning, when there is a first interaction, we have to clarify that what we call as independent expert, which means that the person would be taking the stand, or is it a consulting expert? So the difference that we say is a consulting expert will assist one party in making sure that everything is complete, everything is there. But the role may be more about, let's say, on one side of the party and not taking the stand, to make sure that everything is completely sort of done. And then maybe some other expert can take the stand to assist the trier of the fact. So that's how it starts. But let's say once it is communicated that we are going to be expert witness, then right from the get-go, the independence becomes very important. Even the clarity that, okay, what we can do, what we cannot do. Many of our clients, when they come, they know that, okay, it's not that whatever they will say, we will just accept on the face of it. But that is usually not an easy conversation, because at the time, when these conversations are happening, there may be a strategy that is involved there, that maybe the case will settle. It may not go to all the way. It might settle ahead. So therefore, we should claim far higher amount. We should even try to put in line items that are probably not justified. So it's a long list of, long shopping list. But we are very clear that, once you put in the report, whether it is negotiation on the table, conciliation, arbitration, you cannot change the report. And if let's say, certain things don't get settled and it does go to arbitration, then, the entire report can be discredited. Forget about, maybe the 10, 12, 15% extra that you are trying to claim. The entire claim can be subject to discredit, even your genuine claim. So it's usually a very challenging exercise sometimes, that is involved. I think the expectation setting that, look, we are going to be assisting the trier and not just sort of building the claim to thousands of crores, I think is usually, where the conversations start.
Let me ask Shishir differently. I have seen, like, in domestic arbitrations, when the expert comes, they depose that their client is 100% correct and the other side is 100% wrong. Versus internationally, when we see the experts, they come, they would not 100% certify the claim of their client, but kind of give a more balanced report. What's your take on that?
So, as per my experience in international arbitrations, what I have seen that regarding the expert witness, there is a standard practice that at the time of appointment of experts by both the parties, both the experts should interact with each other even before commencing their assignments. So the tribunal, they insist that both the experts should interact with each other. And for example, if the experts are related to the delay analysis, so the tribunal insists that both the experts should agree on the basic parameters of their analysis, like what is the period of the delay under consideration, what are the data set on which they will be making their analysis, what are the programs, what are the documents, so that there is a uniformity of the basic input for the analysis. So it gives like a uniformity in the approach. That is a different, you can say, point that both the expert can adopt different methodology and approach, and they may arrive at, I can say, different results. But definitely, you can say, the approach will be much more balanced and synchronized. So I have seen in international arbitration, there is a concept of joint report that is, you can say, prepared by both the expert before, you can say, submission of their main report, so that the points of agreement and disagreements are clearly recorded in that joint report. Then later, both the experts, they prepare and submit their main reports in which their analysis and findings and opinions are registered. And afterwards, there is a provision of reply report, so that both the expert can, you can say, give their counter arguments to the other side expert. So the tribunal, members, they try to ensure that the expert's opinion and their report should not be like that two ships crossing by each other in the night. So because the basic objective of the expert testimony is that for the tribunal point of view, so that they can understand the real issue and what is the crux of the matter under the dispute, and they can have, you can say, certain documents and the analysis through which they can compare and contrast the opinion given by both the experts. So therefore, what I have seen in the international arbitration, that you can say the experts are also in the constant interaction with each other during the process of preparation of their different reports. And also at the time of cross-examination, I have seen that there is a, you can say, interaction which is called hot tubbing, in which the tribunal as well as both the experts, they interact with each other. So that way there is a lot of rationality and reasonability is there in the expert's opinion. Thank you.
Let me ask differently, Justice Sistani. When we see the experts, like, reports, there are like, at least in the domestic scenario, you would see there is a 15 to 20% fluff or like, a margin for the parties to negotiate. How, as a tribunal member, you would look at those exaggerations or excesses?
Definitely suspiciously. Why should, if somebody is giving an expert report and if he's an independent expert, then his report should pass the test. So if you examine it and you find on the face of it there are various exaggerations, then you would say that if he can go astray on point A, he may have gone astray on point B and C as well. So there would be an element of suspicion. Whether how deeply one would examine that or look at it is a different aspect. And if you can somehow keep that aside and look at the other sides differently, then maybe yes. But if you find there are systematic exaggerations all through, then I don't think it's a good thing to rely on such a report.
I will just share an anecdote. In one of the arbitrations, one of the experts, he had written that he has acted as an expert in an ICC arbitration relating to oil and gas industry, relating to damages in an agency contract, and we had the a nice fun moment to ask him, is this is the one you're referring to in which you are currently acting, or was this a previous one which you have acted? So I guess experts also sometimes need expert guidance in their CVs. Moving on, let me ask, Jagvinder, how do you usually get cross-examined in these, after you've given the testimony? What kind of questions do you get?
He wants to know how well you are roasted.
Sir, I just want to add one point to Shishir first, and if you allow me. I think the question that we often or the challenge that one expert always faces is that some of the information is not with one side which has hired you, but the information is on the other side. So when one expert is preparing the report, that person doesn't have the benefit of all possible evidence, communications, etc.
Very valid.
That is there. So therefore, in certain countries and in I think certain arbitration rules, there is a process where even before the pleadings, there is a process of affidavit of documents. So what they do is that each party declares to another that what are the potentially relevant documents that we intend to rely on, so that the other party has the benefit to get an advance copy of those, so that when their expert is working, those documents are also considered, because there may be implication. Let's say if a report is prepared and then certain information comes in, I mean, it can totally change the flavor of the report. It can totally change the amount. So I think how do we, in arbitration, complete the document productions, the e-discovery, or as it is slightly more advanced in certain other jurisdictions. If those discoveries are complete, I think the expert reports can be more complete and holistic, because even the data that two experts are looking at is different. Naturally, it is not surprising that the reports will be different. So I think that is one area too.
I may add, certain circumstances, it is better to introduce an expert once the pleadings are complete, so that at least the expert, before opining, they can see on both sides of the picture as to what is the position the parties are adopting, and then on their expert view give their expert evidence.
Absolutely. So I think that is some area to be considered. But anyway, coming to your question, sir, about cross-examination. So I think from expert point of view, it is not hard to say that it is also among the dreadful moments where you never know which side it is going. And I'll tell you genuinely so. In a lot of expert reports, there are a lot of assumptions that are put out there. The assumptions can be, let's say, different scenarios being created, because certain things may still be under, undecided by the tribunal, depending on the outcome of those, factual and legal, issues. the expert quantification, like in our case, the damages, the damage quantification can change. For example, if it is a simple thing could be interest rate. So if there is a delay by one party and that party has to get some interest, what is the right interest rate? Is it 9%? Is it 12%? Is it 18%? It can vary sometimes. So, even if there is a sort of, statutory interest rate put in the Arbitration Act or rules, sometimes, that can be also different. So, an assumption often is made in the report that, the report is based on this scenario and this assumption.
True.
Now, where most of the cross-examination focuses is one on the limitations that we have put in the report, and those limitations can be genuine limitations. The second is, of course, on the assumptions. And so long as, the risk that lies to an expert is assumptions and limitations are made into such a big thing that they can swallow even the proper conclusions that may be drawn, even subject to those limitations. There may still be a lot of things you can conclude, even with those assumptions and limitations, but the cross-examining lawyer can actually ask certain questions where everything may seem as if nothing was done, everything was based on some kind of, like a castle in the sand, because it's all limitations. So I think the areas that we very thoroughly work on before finalizing the report are the limitations and the assumptions, so that on one side, the trier of the fact is able to understand properly that, okay, what were all the limitations of the work that they have done, and if there is a different determination on factual or legal issues, then there can be revision of the amount. It's not that the entire report goes out. There can be certain financial modeling that can be adjusted. So those are the areas we typically would focus on.
Hitesh, as a client representative, what do you think?
Yeah, I just want to add what Jagvinder was saying, that on the availability of the document, actually there is a statutory right available to the other party under Section 26 of the Arbitration and Conciliation Act. And of course, so far the arbitration proceeding, they involve traditional method of presenting expert evidence, like first examination in chief, that is usually now done through by way of affidavit, then cross-examination, and if there need be, then the re-examination. So as far as the right is, the right to have access to the documents, data, findings referred to or relied on by the expert witness is concerned, yes, definitely other party can ask for it. They have a statutory right. In terms of cross-examination, obviously it's a strategy, more of a point of strategy, because while examining the report or looking at the report of an expert, the rationale, what are the rationale, what are the data he has relied on, what are the findings, whether there were cogent reasons, the range of survey he has conducted. So all these things, they are material while cross-examination the findings. And one more important point is that there is a possibility that with the same amount of data, two experts can arrive at different conclusion. So that is the most perplexing situation. So, but yes, the main focus of the cross-examination would be at the adequacy of data, completeness of the data, what type of findings he has relied on, what reports he has used to arrive at those conclusions.
Thank you, Hitesh. Shishir, if I may ask you, do you also get quizzed on the questions of law by the lawyers when you're deposing as an expert?
See, as an expert, definitely I cannot say that I am expert at law, but definitely a basic understanding of contracts and law is there. And a bit of, you can say, not the contractual or the legal interpretation, but the references of the relevant contract provisions are always there in a technical report, whether it is a delay analysis report or the quantum analysis report. But at the same time, what is the standard practice which is adopted by most of the experts, that they, in the start of their report, they provide a disclaimer that this report is strictly as per the, you can say, uh, as per the, if it is a delay report, it is prepared strictly as per the delay analysis methodology and programming and planning aspect, and it is any legal or the contractual interpretation is out of scope of this report. So therefore, if any question is asked which is related to the interpretation of contract and law, then the expert can say that it is beyond my scope of expertise.
Thanks, Shishir. I think by and large we've covered most of the issues relating to the experts, and I would rather open the floor now at this point to see if anybody has any questions on. We have the first one.
I can do without mine. My question is about candidature of expert witness. Like Rajiv Sahai pointed out, it is not about who he is appointed by, because at the end of the day, arbitrators are experienced people. Their decision, their adjudication will be based on merit, experience, and equity. Mr. Hari Salve always says that after independence for initial 50 years, all Indian arbitrations were about construction, mainly regarding railway, highway, power plants, and dams. So we have a galaxy of people experienced who can be put to use as expert witnesses in our arbitration. So shouldn't we have tendency of appointing retired chief engineers or NHAI chief or GMB chief as expert witnesses? They may be under the aegis of, let's say, Masin or KPMG, but their report will bring home a point. In construction industry, there is a term called master builder, who has experience in architecture, design, structural engineering, execution, everything. So not necessarily expert witness should be someone. For example, if there is a GMB port related issue, we can rope in expert witness from Bombay Port Trust, who has worked as higher up in Bombay Port Trust for, let's say, 3-4 decades. So shouldn't we put the knowledge base that is already in existence to use as expert witness? Maybe Lordship, maybe.
Yes, why not? And it does happen. It happens many a times. Retired chief engineers, their opinions are taken. They're subject to witnesses. You're absolutely right, and there's nothing wrong in that. They make good arbitrators also, and because they have the subject knowledge. And in a lot of these contracts, especially, for example, NHAI or any of them may decide to nominate them as their nominee, because they would know, they would have the expertise. Going back again to our earlier discussion, subject, if you're, you know your subject, then why should you not be an expert? And then you would be termed as a credible witness. But if your expertise and knowledge is an A and you're deposing for B on B subject, then all those questions which I said, you would say, okay, this fellow has no knowledge, no idea about this. But a retired person from NHAI in one of these buildings, he would say that, look, I worked under this for 10 years. Yes, I have knowledge. I know how this is done. You're right. And there are panels, right?
Do we have any other question? This.
Hi. My question is that in most of the domestic arbitration, my experience has been people produce a CA certificate. Now, what is the validity or authenticity of the CA certificate? That is real question, because I have seen number of judgments. Some of the judgments say that, okay, it is valid. Some of them disregard it completely. And one more issue which troubles me as a counsel is that I see that when the CA certificate comes, it is from some XYZ CA. Whereas if you talk of the statutory auditor of that company, that is Big Four. So why don't they go back to the big four only, their statutory auditor, also for giving a CA certificate so that there is some more authenticity to it?
Jagvinder will answer this. He's a
Yes.
CA also.
No, sir, I think you should just ask them to get it from their statutory. Yeah.
That's not in my head. I am a counsel for the other side, and they bring that certificate.
Yeah. No, I think as Justice Sistani said, see if
Roast him then. Put him on the burner.
no, I think as Sir said, see the ultimate point that you want to get to is that a valid sort of certificate or is it not a valid in the sense of whatever it is trying to say. For example, certificate about the past turnover, the certificate about the profits of the company and all that. Yes, yes. And if as Sir also said, let's say if you have some sort of suspicion, or maybe if you look at it skeptically, there can be alternative evidence, there can be alternative way to substantiate it. So my view is that, look, I wouldn't want to sort of discredit all the certificates like that just on the face of it. But I think looking skeptically is what we can do in that. And even we ourselves, like sometimes when we prepare the reports as well, we also get a lot of other certificates that we have to rely on. There may be past certificates, there may be certificates from the other side. But what we have to do is get to and maybe re-verify some of the facts, re-verify the turnover, re-verify the profits or the expenses that might be stated in there. What I would also caution is sometimes there is a wording that is based, and if that wording is based, then we'll have to totally discredit. For example, based on the information or explanation provided by management. Now, whenever there is an explanation provided by management, there may be no independence, due diligence done by that chartered accountant. In that case, I will totally want to re-perform almost the entire work. And then, of course, based on your role, you have to decide maybe something similar as well.
Thank you. At this point, I think it looks like it was a good panel that we have not been roasted much, and we will let the next session start. And thank you everyone for this audience.